chair, implementation committee, and will be the mover of the same deliberations for this General Oversight Committee. The matter at hand is something that I think is of public interest, significant public interest, but more importantly, significant interest to the county government of Nandi, both the county executive and the county assembly. As a chair, I would just want to provide a bit of guidelines, a bit of directions, and then we immediately delve into the session. I want first to take this opportunity to introduce our team. I would ask each honorable member to identify themselves. On my chair here, we'll have my co-chair, Honorable Gideon Koech, but we are equally flanked by the relevant committees, the Committee of Health, Honorable Dr. Sanga, as well as the Budget Appropriation Chair will be with us. But I would want just for members to identify themselves before we proceed, starting with co-chair.
Honorable Gideon Koech, Chair Implementation.
Honorable Dr. Paul Sanga, Chair Health and Sanitation.
We can start with the immediate row after us.
Honorable Cornelia Some, Vice Chair Tourism.
Honorable Terry Mayo, Vice Chair Education.
Honorable Robert Kirwa, Lance Chair.
Honorable Rufo Sakuto.
Honorable Magdalene Rono, Vice Chair Agriculture.
Honorable David Wambok, Chair Delegated Legislature.
Honorable Nancy Chamtai, Vice Chair Health.
I can see a member has walked in. Kindly introduce yourself quickly.
Honorable Joshua Ngetich, MCA Kusaragiwat.
Come, and the Chair Finance. So without wasting time, I would wish I think as per our invitation, I can see the entire team is here. We have the County Public Service Board, we have the legal, head of legal, we have the Department of Health and the Department of Finance, as well as the County Secretary. So I think that is the team that I think will first take an oath, then you can introduce yourself, then I can lay the rules, the groundworks. I want the staff.
I, Francis Kimboy Sang, do solemnly swear, affirm that the evidence I shall give before this committee on the matter under consideration shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you.
I, Alfred Lagat, do solemnly swear that the evidence I shall give before this committee on the matter under consideration shall be the truth, the whole truth, and nothing but the truth. So help me God.
I, Ruth Koech, do solemnly swear and affirm that the evidence I shall give before this committee on the matter under consideration shall be the truth, the whole truth, and nothing but the truth. So help me God.
I, Aruseil Sebat, do solemnly swear that the evidence I shall give before this committee on the matter under consideration shall be the truth, the whole truth, and nothing but the truth. So help me God.
I, Jacob Sisei, do solemnly swear that the evidence I shall give before this committee on the matter under consideration shall be the truth, the whole truth, and nothing but the truth. So help me God.
I think, George, maybe we'll need your legal input. You can.
I, George Tarus, do solemnly swear that the evidence I shall give before this committee on the matter under consideration shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. I think by virtue of taking the oath, you've equally introduced yourself. And quickly, I'll just make the introduction and appraise. I can see honorable members that have walked in. I would ask them to identify themselves by the microphone, led by the majority leader, quickly.
Pius Singoe, MCA, Capital Kamayo Ward.
Cynthia Muga, MCA, Kilibwani Ward.
Who else who hadn't introduced himself?
Mengage, MCA, Lesos.
Okay. I had seen majority leader.
Yeah, stepped out.
Yeah, stepped out. Thank you. Now, honorable members, as well as the team from the county executive, welcome to this. Without wasting time, the Committee of the General Supervision is mandated to report back to the House on Wednesday through chair implementation on this fact finding. I wish to draw the attention of the House as well as the Executive Committee that the matter arose out of a motion that was adopted on the last Thursday, at the floor of this House, where the House has been mandated to fact find. This comes on the backdrop of two matters. One, there's a matter filed at the Principal Magistrates Court of Kenya at Kapsabet, case number 51 of 2020, where the Nandi County Assembly has been listed as an interested party. Secondly, there's a notice, I think, that was published by the County Public Service Board regarding the same matter, and out of it, the County Assembly saw it fit to be able to fact find and do an inquiry with a view of arriving at a position for the County Assembly. One of the matters that the committee had to grapple with, or the chair being the speaker, was whether indeed we were sub judice. And from our interpretation is that now that we are an interested party, we are expected to be able to assist the court with our position. And if you look at the nature of the summons issued to us, we've been listed as Nandi County Assembly. It was not summons directed to the speaker or the clerk or an individual member of the County Assembly, meaning the County Assembly must have a common position to be able to. Honorable Walter, please come to the front, take a seat. I would want the two to introduce themselves. Honorable Walter, take a seat, we expect you here. Maybe introduction, starting with those that are not introduced. Majority Leader.
I'm David Koech, MCA Kaptumo, Leader of Majority.
Okay, I'm Honorable Walter, MCA Kabiet.
Thank you very much. So as I was proceeding, now that we've been listed as a county assembly, the County Assembly makes pronunciation through resolutions of the House. For us to be able to give a position for consideration by a court of law, the County Assembly must have a position. And we saw it fit, due to the arising nature, now that a notice had been issued purporting to cancel or to nullify the appointment letters of the same, the County Assembly felt that we may not be in a position to give a position unless and when we are able to get the facts clear and be able to have one common stand and give our position. So in this case, we avoid a case whereby we can be listed as acting sub judice. We are not seeking to make a determination to defeat the court's process. However, we are seeking to get to have a position for the County Assembly as an interested party for purposes of compliance, because we've been served and we are expected. So as a speaker, I allowed the motion of general importance, and we mandated the implementation chair, who is the co-chair of this session, to be able to ask for the team involved from the county executive. And from our letter, we fingered out the County Public Service Board. We received a letter from the chair that he is medically indisposed, and he sent the CEO, acting CEO, as well as the vice chair. We equally serve the Department of Finance, being the critical team that discusses or gives a determination on matters pay. We equally gave a summon for the Department of Health, being the line department that was expected to absorb quite a number of this. Then we have the county secretary being the head of kind of public service within the county executive and the link between the county public service board and the county executive. Finally, we saw also it fit to include the head of legal, that is the county attorney, because at the end of the day, during the court process, the first, second, third, fourth respondent are represented by the county attorney for the county. We equally had our team from the assembly, that is the clerk assistants as well as the legal. Now, in order to ensure that the matter, we are able to move with speed and get clarity, our rules of engagement are pretty straightforward. The entire team is here, and we've prepared a list of guiding questions on this specific matter. It is purely on that issue about the notice that was issued and about the 381 stuff. Each of the county assembly member will have a right, but will be moderated by the chairs. On the table, I have chair implementation being the co-chair. I have the chair health and chair budget, having been involved on this process before. So our questioning will be from the members, and we will ask the team from the executive a question that touches on your area. If it is finance, we expect the team from finance to be able to handle. On the public service board, the two of you will be able to handle. County secretary, just like that, so that we can move with speed and you'll be able to. So without wasting time, I just want to open by giving the three teams. One, County Public Service Board.
Excuse me, Chair.
Yes, Honorable Mengechi.
Before we proceed, the matter you've referred to as sub judice, you remember, Chair, I raised that matter during the moving of the motion. And you said the county assembly had not been served. But today you have confirmed that the county assembly is an interested party. And as per Standing Order 88, this matter is before a court of law. And it's very clear, 88C, civil proceedings shall be deemed to be active when arrangements for hearing, such as setting down a case for trial, have been made until the proceedings are ended by judgment or discontinuance. So, Chair, I believe the county assembly, as we know, as per the constitution, has the same powers as the High Court. And I believe this matter has not been determined, it's still active. It would be prejudicial and improper for the county assembly to proceed with this matter when it is before the High Court. Chair, I remember you said there was no evidence that the case was in court. I would request your indulgence so that maybe the team, the legal team, can present evidence that indeed the case is active in court. Thank you.
Honorable Mengech, I'll refer you to Standing Order number 88 that you've mentioned. 88.2, a matter shall be considered to be sub judice when it refers to active criminal or civil proceedings and the discussion of such matter is likely to prejudice its fair determination. So take note of the same. Secondly, 88.3C talks about civil proceedings shall be deemed to be active when arrangements for hearing, such as setting down a case for trial, have been made until the proceedings are ended by the judgment or discontinuance. When we made the pronunciation on Thursday, we equally did our due diligence and confirmed the same day that we had been served with the notice of summons as interested party. And number two, we also perused the court file and we were able to confirm that there was a time period that had been given for parties to comply, which means if you look at 88.3C, which means civil proceedings shall be deemed to be active when arrangements for hearing, such as setting down a case for trial, that matter hasn't reached that particular position. Number two, going back to 88.2, a matter shall be considered to be sub judice when it refers to active criminal or civil proceedings, and the discussion of such matter is likely to prejudice. As I've clearly stated, ours, we are not here to make a determination to contradict the court process. However, we are seeking to arrive at a position so that as a county assembly, when we proceed to the court, we have a common position. If you look at the nature of the summons issued to us, it is directed to the Nandi County Assembly. A county assembly makes resolutions through a resolution of the House. Previously, you've seen that in court cases, we are normally listed personally. For example, the Speaker and the Clerk. But if you look at the nature of the summons, we've been listed as the county assembly. So a position of the county assembly is needed. How do we arrive at a decision or a position of the county assembly for consideration or for onward transmission? A resolution has to be made on the floor of the House. In this case, what is the nature of the resolution? Is the resolution likely to prejudice the fair determination? That is not the case. We are seeking to comply by going to court with a particular position that the House, from their fact-finding, basically inquisitorial process, would have been able to do. Lastly, by virtue that Standing Order number 88.3c gives specifics as to what is determined to be active, which talks about setting down case for trial, the matter hasn't yet gotten to that level. So for us, seeking time to be able to file our response with a specific position of the Assembly, this process today is basically to arrive at a position and should be discussed and determined by the House, and then we proceed. In this case, we are not seeking to prejudice a fair trial. Thank you very much. So for the executive team, I'll give you each, because in the interest of time, the 4 teams.
Maybe, Chair, I think before that,
yes,
I remember the aspects of the motion specifically talked about teams to appear. I am not seeing the chair, Nandi County Public Service Board. I think before we proceed, we should have an explanation to that.
Thank you very much. I wish to inform the entire House that we received a letter for the medical predisposition of the chair, and in his place he sent the vice chair and the acting CEO of the board. And I think that is why Eliseba and Cisse are here to be able to answer on behalf of the board. Thank you very much. Quickly, I will start with the 2. So quickly, I would give each of the 4 teams 2 minutes to maybe give a history of what they know of the matter. Then I hand over to the chair to go for questions. Just 2 minutes. Brief what you are aware of and in your area. So I'll start with the county secretary, followed by the Department of Finance, Department of Health, and lastly, County Public Service Board. Quickly.
Thank you.
Point of order, Chair.
Yes, Honorable Kipkurui.
Honorable Chair, I think it would be proper if we have it in chronological order so that we are building one history, or when one member of the executive explains the history, it informs the next, so that we are not going to be repetitive, so that we are in an orderly manner. I would suggest, Honorable Chair, that we proceed as this, that we have the CEC for health, give us a position, because this is a matter that is customized at the Department of Health. We have the CEC for health make a presentation. Then we have the service board make their presentation. Then the CEC for finance. And finally, the CS, so that, Chairman, we don't lose any direction. So I suggest, if that is agreeable, Chairman, that we go by that direction. I so suggest.
Okay, Honorable Gideon.
I think I would. I love the idea by Honorable Kipkurui, but I would presume that now that the lead of this matter was lifted by Nandi County Public Service Board, it should be the Public Service Board to go first, followed by the department, then, or followed by the CS as head of public service, then the department itself.
Okay. Any other suggestion? Then with that, I think we'll give the County Public Service Board. You'll pick one person. Number 2, we go to the County Secretary. Finally, Department Health, and the final person, Department of Finance. Let's go.
Honorable Speaker.
Yes.
Kindly allow me to make a comment.
Yes.
Thank you for according me this opportunity and inviting the entire team for the purpose of what you have explained. And we came ready for that simple reason that together this is a matter of public interest and all of us have to be in the same page. Just before the board rises to makes their presentation, I am not clear whether our county attorney still had an issue to raise on the same matter that was raised by Honorable Mengich.
Francis, I think on that I have already given a determination that settles the matter. But we'll give him a chance later to make his presentation. So I'll start with the board immediately. Okay, the service board? Either of you? So the vice chair, proceed.
Thank you so much, Chair. As I said before, I am Arusei Elseba, standing in for our chairman. I'm the vice chair of the board. I came along with our CEO, the acting secretary, Mr. Sisei, and Nancy, our legal officer. And as we have come here, I really do appreciate that this house is a house of rules and regulations, and we are law-abiding. When we came in as a board last year, we found this process ongoing, and we have always desired that we come to the conclusion of this with many consultations that have been made. And we want to really appreciate the fact that we are all here together. The people that are in question are the residents of Nandi. We are all interested in it. And as you have ruled that this matter is of public interest, indeed we appreciate that, and we would like to thank you. However, I still would like to mention the fact that whatever we say here can be used as a sub judice, but as we have said that we are going to deliberate on it as consultative, and we really do appreciate. We have really had very many consultations concerning this matter. The board is a hiring agency, and as such, we are guided by rules and regulations that govern the procedure of hiring people. And so, even as we mentioned, I have, when we were invited to the county assembly in regard to the summary dismissal and constitutional rights of the employees, all these things, as we mentioned, as we are before the courts concerning this, I will be guided as to whether we really would like to delve into all the necessary issues. But what we do know is that as a board, we have taken time to go through every detail of what has happened that has brought us here. The fact that we are here means that whatever we have done in the past, we have not been able to conclude. And while we were still at it, this case was taken to court. The matter was taken to court. And sort of like that tied our hands as to why we made whatever decision we made. It was a part of the process. And for the board, ours is to look at the processes that culminate into whatever issue is being raised. And so maybe I'll just ask the BS, our secretary, the acting CEO, to make a brief comment as we continue, and our legal officer will also do the same. But otherwise, we appreciate that we are here. We need to put this matter to rest because it has gone on for long. And we have had so many consultative meetings all along. And I think us being here so that we are able to make it properly rested, I think it is good, and we do appreciate.
Now, let me guide you.
Sure.
There's something I need to bring to your attention.
Yes.
The county assembly, whenever the reason we ask you to take an oath is because information is privileged, right?
Yeah.
We just don't ask you to shed light for the purposes of indicting you. We are not here to indict you because we have a stake in this. We want to have a common position. The house needs to be guided. And whatever is made here will be for the purposes of the county assembly. Sure. Secondly, you have yourselves entered appearance in the matter in court. And you are aware that the same board took the step to issue a notice. And that is what has triggered this. The moment you issued a notice, it means your processes were active. There was no consideration of the court matter. There was no consideration of sub judice, because if it was sub judice, it would mean you would have entered into a moratorium in a case where you are unable to execute or to act or to make any direction. But by virtue you acted and issued a direction, it is what it has brought us here. The move of the motion, the chair implementation will tell you the trigger is after a notice was issued. Before the notice, all of us were at a place of, let us wait and see what takes place. But you took the initiative.
Sure.
You took the initiative. By virtue you took the initiative, we are just now in the same position where we also need to put in our comment. We need to put in our direction as a house. I cannot make a decision for the house. The house has to make a decision collectively. Remember, as I have directed, we are not seeking to counter the court process. Sure. We are an interested party, and it's a privilege. Yours is just because the same information you are filing in court is the same information you have. You would expect us not to go act against you because we are part of the county government. But if you pit us against you, it becomes very difficult. Sure. And that's why we are seeking to consolidate. And that's why the only thing I ask for you is just to give a brief history, what it is, that's enough. Then if there's any question, the honorable members were to ask the questions. That was the position.
Chair, when the order, Chair.
Stand guided.
Yes, Honorable Kipkurui.
Honorable Chair, in the presentation of the Vice Chair, you've not heard about two things. You have not heard 381. You have not heard whether they were fired, whether they were employed. I think that, Chair, that is why I still insist. If we can have, because the matter in discussion is about the health care staff, the support staff that were employed and now they have not been paid and now they have been fired. So we want to hear the talk around the three issues. So, Chair, I think the issue about all good relations, no, that's not our business for now. So, Chair, I still suggest that we have the position from the CEC, make a presentation on the issues surrounding the 381 health workers, so that it forms the case that we are going to discuss here, Chair. Because, like you have directed, we want to have a position as a county assembly, but inform position. So, Chair, I still suggest that we take that direction and let them limit themselves to that issue of discussion, Chair.
Chair. Chair.
Honorable member. I can't pick who it is.
Hata mimi pia naunga mkono tuanzie health alafu tuende hivyo polepole kwa sababu health ndio ilikuwa inaandika watoto.
Honorable member, take a seat. So quickly, lastly, I'll just give you 2 minutes. You wind up on your bit. I go to County Secretary. I come to Department of Health. Quickly. I hope we've understood each other. Just briefly as it is. Proceed. Acting CEO, quickly.
Thank you.
Thank you, Chair. Once again, my name is Jacob Sisei. I am a board member and also acting CEO and secretary to the board. Mine actually would be just to strengthen what the Vice Chair said, that when we came in as a new board, we actually deliberated on this matter. We have actually carried out extensive investigations into this matter. And whatever decision we made of nullifying was actually as a result of the ongoing investigations and the decisions we did. You will remember, Chair, that the claimants in court are actually basing the arguments on an advertisement of 119 support staff and cleaners. The nullification which actually we carried out as a board was actually for 381. And it was not a decision that we reached or we arrived at just, quickly. We also took time. We carried out enough investigations. Secondly, Chair, I still need to be guided here. I think the question is the board, or what triggered this meeting was the fact that the board made a decision to nullify those cases yet it was in court. I still need to be guided if we are okay to proceed with this matter, because I think sub judice is sub judice. If we made a mistake nullifying it while it was in court, then I don't know if it will still be in order to make the second wrong here and discuss the same matter which is in court. Thank you.
Acting CEO, I will give now, I think before the chair can come in, the questions will speak directly to what you've raised. That is exactly what I needed. I just needed the opening remarks because I want to open the floor. The members are prepared with their questions. It touches even including what you're saying. That was the only thing I needed. So that because I want to give chance now to the chairs and the members to quickly go to the question. So let me quickly move to County Secretary to make your comment on the same. I go to Department of Health. I finish with Finance. Quickly, 2 minutes. I open the floor to the members.
Chair, would you want to leave that unchallenged, Chair?
No, I'm not leaving it unchallenged because it is the substantive question that you are about to ask, led by Honorable Gideon Koech.
Okay.
Yeah, proceed.
Thank you, Chair. Thank you. In summary, I would say, as the members of the board have given their brief, that in 2018, we sought to recruit staff, cleaners and support staff. And the same request was made to the board, and they concluded the process in 2019. And upon concluding the process, we realized that there was a problem in numbers not adding up. And we sought to find out why, which we did together with the board. And in the process, the board realized that there was an irregularity. And I think that culminated to the decision of the board to nullify the process. Thank you.
Department of Health, quickly.
To the honorable members of the House, I would like to appreciate this session because this is a matter that we have been all in consultation, and I do appreciate the fact that it will help us rest this case. First, allow me to just explain that.
Speak to the microphone.
To just explain the fact that according to the letter that we received to appear before the House, Public Service Board under Article 235 is in charge of staffing, hiring, firing on behalf of the county government. And in 2018, as a department, part of my function...
CS, you switch off your mic so that Has is clear. Proceed.
Part of my function is to coordinate the functions that happens in my department, and as the county secretary stated that after reviewing the needs of our department, we did write a letter to the county secretary on an intent to hire after we reviewed our budget. And the reason why we did that was because we needed the support staff. The contracted services at that time were underpaying the employees, were not providing them personal protective equipment, were not giving the proper training, were not buying the needed detergents that we needed. They had delayed in salaries. There was no supervision in the company, as well as giving the IPC and security protocols that were needed to protect our employees. And one of our mandates as a health department under the WHO, human resource, not only the number, but their welfare, their distribution, their training, and their practice of best practices lies in our department. So we decided to end the contracted services so we can provide better welfare for our healthcare workers. And also, in addition, the Danida funds were coming to an end in 2020. And we had to plan for that as a department. So with the budget of the contracted services, we made our intent to our county secretary, who made the intent to the Public Service Board. And the Public Service Board has the mandate to do the recruiting, the advertisement, the interviews. And once the hiring has been done, the employees are supposed to be sent to our department for deployment. The employees that were given the letters were more than what we had requested for. And we had complaints, not only from the communities, some honorable members of the House came to my office, and also from the facilities where we had had a long-standing employees who had had suitability tests, because part of our goal was not to displace people who had been in facilities for over 19 years. We did get consultation and a letter from the contracted services to release the employees if they fit in the interview to be hired by the Public Service Board. So where we stopped was the required employees versus the numbers that were sent to our department. And since then, I know the entire House is aware that we have had several consultative meetings. We had one as a department, we had several, and we were in the process of trying to resolve that issue, which at my desk and at my mandate, I do not hire and I do not fire. And as a department, I will say it's not only in the health department, but other departments, not only in Nandi County, but nationwide or even worldwide, where you have human resource issues. And at my position, with policy, you make your policies based on the issues that you have. And if at that time we had a digitalized platform, it would have been easy to notice that we had the excess in numbers. We would have also had a head count of who we had. We would have known the distribution. Likewise, we would be sharing the same platform with the Public Service Board in regards to the same. So, with the several consultations, the matter is in court, and we are awaiting the recommendations from the court.
Thank you. Quickly, Alfred, and as we finish, and then I'll hand over to Gideon to speak.
Chair.
Honorable Chepkwony.
Chair, if you may allow me to make 2 follow-up questions to the CC so that we are progressing.
No, I wanted now the questions to follow immediately. Just note them. Alfred is making just 2 minutes, then I now open the floor.
Thank you, Chair, and the honorable members in this House. Mine is brief. It is really to do with the budget. If you set out to hire 119 people, it means that you've made a provision of paying 119 people for the financial year. If you end up with 381 people, the only reasonable thing is to cancel the whole process because it's not supported by the budget. And therefore, the best thing to have been done is to cancel and to get the process right afresh, notwithstanding the fact that, of course, there is need for those staff. And therefore, for me, would have been to have the process cancelled and a speedy resolution by way of hiring afresh a number of people that meets the budget. The provision budget would have been about 20 million. 381 would take you to about 80 million. So therefore, it really can't be accommodated. An escalation of 50 million can't be accommodated anywhere in the budget. Thank you.
Honorable Gideon, pick from there the questions, and honorable members, you will be guided.
Thank you, Chair. I think basically anyway, the floor has been open for questions, and I think we will allow members to just ask questions, but just to set a pace is the service board is here. They are talking of 119, they are talking of 381. So the best thing for a start is we would like to have ask the service board to clearly show in document form how many staff were actually to be employed. That is the advertisement by the advert that you put on the dailies, and on the same note, clearly indicate, because you carried out an interview process, could you also shed light and provide the said position that were actually the shortlisted candidates, and probably also the entire, because you have data, the entire list that probably did make the application. And lastly, so that I allow members to maybe ask the rest of the question, could you shed light on this extensive consultation towards nullifying? They said people that were employed. So I think that let me just end at that point so that maybe the rest of the members can ask questions. But on follow-up, so that you answer all, anybody who is who can answer that. As you shared the advert for the list of support staff, as a follow-up question to the fact that there was a higher number, and as mentioned by the CC Finance, in aspects of budget, would you also share the advert for the nurses, clinical officers, and the likes that was advertised and subsequently filled, and keep the aspects on that particular note, how many were advertised, how many were subsequently employed, and what was in the budget, the CEC, and to someone on the issue of UHC staff, how many were advertised, how many were employed, so that we can tie in trying to address the anomaly in 381 using the past and the subsequent one, because UHC is more recent and the nurses and clinical officers is a bit earlier than the 381, so that we can tie the three. Thank you.
The service board, quickly, before I can take the next question.
Honorable Chair.
Yes, Honorable Ngetich.
It is just maybe I'm jumping the gun, but what I wanted to ask is that we hear that the team had a plea to the court that they settled the matter out of court. Can they share it light? I think that can solve all our issues, because if they have maybe a way where they can settle this issue outside the court and everything will be okay and this house can consent it, there is no need of going down, because they must have by requesting, they have something at their hand. So there is no need for us going down. Even what the Honorable Chair is asking, whether they advertised 119 or what, people have letters, 381, and that is what we are after. We don't want to know about 119 or so. So if that is the case, let them tell us how they want to solve the issue and then we close. Yeah.
Honorable Ngetich, you are out of order on one aspect. Every single member has a right to ask a question. On your first part, you've asked the right question. Your question will be answered by the county attorney as to the position they have adopted on the matter of court, and if indeed they have entered an application to seek out of court settlement and what is their position, that will be answered by the county attorney. But first thing first, I would ask the service board just to respond to that. It's just factual.
Chair.
Honorable Mengech.
Yeah.
Honorable Mengech.
Chair.
Proceed.
I still believe the chair has bulldozed his way through by saying this matter is not sub judice.
Which
chair?
Myself or which chair?
Yeah, the chair who is speaking.
Proceed.
Yeah.
Proceed.
My chair.
Proceed.
Fact is, you remember on Thursday when Honorable Gideon moved the motion, I did ask you as a speaker that this issue was prejudicial because the issue was in court. And your response was, we don't have evidence that the matter is in court. And you even said the assembly was not party. Today you have confirmed that indeed
Because we are not being served.
the county assembly has been served.
As
I
an
did request the...
as an interested party?
Yes,
Honorable
I did
Proceed.
request the legal team to confirm whether they received summonses, and they confirmed that they did a long time ago. Secondly, Honorable Speaker, you have said this matter is not sub judice because we are not delving into the details of the case in court. Unfortunately, going through the questions, question 1 to question 20, all those matters deal with the issues being handled in court. Chair, as legislators, we are supposed to respect the law. Chair, if somebody went to court today and said, presented evidence that we are discussing matters before the court, definitely we shall be liable in a court of law. Chair, we must respect that the matter is being handled in court. And sub judice basically refers that the matter is in another court of law and it cannot be discussed in public. We are in public here, we are in public in social media fora. So, Honorable Chair, we must respect the law. You have always, this is a house of procedure. Honorable Jepkwani is here, he has always said we are a house of procedure. This matter is before court in Eldoret, and I cannot see why we should proceed and discuss the issues at hand.
Honorable Chair.
Honorable Chair.
Honorable, let me first take Honorable Kipkurui, then I can come to this. And County Attorney, you will first answer the first question of Honorable Ngetich. Honorable Kipkurui.
Honorable Chair, that is why from the onset I did seek that I do a follow-up question so that we are well advised whether to proceed or not, Honorable Chair. My question was going to be directly follow-up question to both the legal, that is County Attorney, and the Service Board. Now that this matter is in court, why and which basis in law did the Service Board find to be able to do an advert recanting on the application letters or the appointment letters of the 381? Because by the time that gazetteman went to the media last week, already the matter was in court 3-4 months ago. So if there is a loophole that they found to be able to act when the matter is still in court, then we'll have also a procedure. We'll use the same loophole to be able to proceed in this sitting. Failure to which, then we will be legally sitting.
Information on... Chair.
Additionally, Chair.
One person, one
Chair, I think that I
honorable members, until he finishes, then I will give majority leader, followed by Honorable Kirongo, and lastly Honorable Ngetich.
Because, Chair, we have to be very clear. The Service Board and the County Attorney cannot set terms for us. They went against the court. And then they come here, when we want to engage in the same matter that they have already engaged against the law, then they remind us that there is a law. So I think, Chair, that should be set out clear first. Let them go first to explain to us as to this, the reasoning behind action while the matter is in court. Then we can be able to say, if there is no law, then this sitting will be illegal. Because clearly, Chair, you and all of us know that if this matter is in court, we are going against the law. So if, Chair, that can be set clear first, Chair, I think that before anything else, if that one can be set straight, Chair, then we can be able to ask other questions.
Information, Chair.
Honorable Majority Leader first.
Let me inform.
I will give Honorable Majority.
Thank you, Honorable Chair. I also support what Honorable Mengage has said, Honorable Chair. This matter is sub judice. Yeah. We should follow the law, Honorable Speaker. This is a house of procedure, as has always been said by Honorable Kipkurui, up to including yourself, Honorable Speaker. Secondly, you cannot make a mistake because somebody else has made a mistake, Honorable Speaker. Yes. That one is wrong, Honorable Speaker. If the service board made a mistake, for us, we are the people who make laws, Honorable Speaker. We cannot now say, because the service board terminated the contract of those letters for those who had been given appointment letters, that one does not give us a leeway also to make a mistake and start deliberating on something that is already in court. I support what Honorable Mengej has said.
Honorable Kirongo, followed by Honorable Ngetich. Speak to the microphone quickly.
Thank you, Chair.
Then Honorable Elfas and followed by Honorable Terry.
Honorable Chair.
Honorable Hilary, I've also taken note.
Honorable
Kirongo.
Thank you, Chair. We are all interested parties, Chair. Whether it was the team of employees were nullified, we must follow the law. You know, if we continue, Mr. Speaker, we have a lot of questions to ask. We represent our wards, and some of us feel that we were left out. We are not, in fact, if you can ask me, Mr. Speaker, I will then say, whoever advised the government to recall the appointments was right. But what is here, Mr. Speaker, let us follow the law. Because if we continue as if the government did wrong, Mr. Speaker, and yet some of the wards, like mine, have zero employee out of 381, then which justice are we looking for, Mr. Speaker? Chair. So let us follow the law.
Thank you, Honorable Kirongo. You've made your point because I want members to
Thank you.
contribute. Honorable
Thank you, Chair.
Ngetich quickly, then Honorable Elfas, Honorable Hilary, Honorable Terry. Then I take it to the county attorney.
Thank you, Honorable Chair. What actually I wanted to say has been said by our majority. I wanted to inform Honorable Kipkurui. Always you have told us that this house is a house of rules and procedures, followed by our chair implementation, who normally sits on the chair, and he normally guides us on rules and procedures of this house. Honorable Kipkurui normally does the same. Me, I am in support, but my hands are tied regarding this case. So that is why I was inquiring whether it is in order. Otherwise, I think I had put across.
You've made your point.
Thank you.
Thank you. Take
but for the case now, I am in support of Honorable Mengej on this issue.
Honorable
Thank you.
Honorable Elfas, quickly.
Thank you, Chair. I also want to echo my sentiment that actually what Honorable Mengej has said is the due legal process, because I have heard that actually the 381 employees was per much, what could I say? I have heard the member for finance saying actually this matter, if we are to settle and do it afresh, that is when actually we can get a solution to this process, because we have dealt with this matter several times. We have had several discussions with the members actually who are concerned. Now that actually, since we had not arrived with the process on how we would forge the way forward, and now the court has taken over it, what are we discussing here? What do we want to make it here clear? When with all the time we have discussed, we have not come up with a conclude solution. I suggested that we leave this matter to the due process, actually, which is ahead of us, so that when they come up with a solution, we sit down here and discuss whether we'll agree or not.
Honorable Hilary, quickly.
Thank you, Mr. Speaker.
Followed by Honorable Terry, then I'll give the county attorney.
Mr. Speaker, I'm of the same opinion. And
Honorable Justin, I've heard you. You will come after Honorable Terry.
I'm of the same opinion, Mr. Speaker. I have two concerns. Number one, whether by...
Honorable members, only Honorable Hilary is on the floor.
Whether by determining that we can proceed, regardless of the case being in court, if we have a precedence where a parliament or a house of an assembly has proceeded with such a case or such a matter that is in court, if we don't have Then, Mr. Speaker, I have the following suggestion. Number one, that we leave the process to proceed as it is. Number two, that if the Assembly is interested, and we are, in getting involved in settling the issue, the Assembly proceeds to register interest and to get enjoined on the case that is in court. Number three, that Mr. Speaker, the House can take a step and intervene on the parties, the staff, and the executive, and to have the case settled out of court. And there then, we proceed and come and handle the issue here in the House. Otherwise, I support what Honorable Mengej proposed.
Honorable Terry.
Thank you, Honorable Speaker. It's unfortunate that it's like we are going back to square zero. I only want to sympathize or empathize with the vulnerable team that was employed, the 381, regardless of the process, regardless of how they were sneaked in and noticed, Honorable Speaker. Because if it was meant to be 119, not even 170 as I had, and now they arrived at 381 through, I don't know what means. It's shocking that it's possible that we have been hiring numbers, sneaking them in, being unnoticed, and have worked since November. They are getting to 1 year, serving us, serving in our health department or whichever.
Point of order, Mr. Speaker.
Let her finish.
She is contributing on the
No,
matter.
I'm not contributing.
Honorable Terry,
said
be
I'm
guided by
sympathizing.
purely
So
that question that has been raised. It's a
if-
preliminary objection.
If it's true that we are not supposed to be touching on anything that is in court, then let the status quo remain. Let them revoke the nullification, let them remain until the matter is settled out of court. Thank you, Honorable Speaker.
Honorable Justin, the last one, then I go to County Attorney.
Thank you, Honorable Chair. I think, Honorable Chair, this problem all is the Public Service Board. The Public Service Board keep the appointment letter and also they nullify when the matter is still in court. So now we need to seek a way of dealing with the Public Service Board. Why did they make a mistake of nullifying the 381?
County Attorney.
Just
you
before the
speak.
County Attorney.
I thought that because it is a preliminary objection on a question of law. Did you want to comment on that? Because I had given that right to County Attorney before I can give my determination. It's a matter that we
Just
have
want
to
make some clarification.
Please.
On the same. That I was able to read through the response that we made to the court. And I am clear in my mind that at the very onset, the questions that were posed by Honorable Gideon, all of them are appearing there. And their matters substantively before the court. Thank you.
Inquiry to Honorable
I will
CS.
not take
To
the
Honorable
inquiry.
CS.
I will not take the inquiry. I will not
No,
take the
I think,
inquiry.
I
I'll
think-
only,
I think
maybe
it
the
is-
chair,
I think it is
because he's
important-
mentioned.
It is important.
Chair.
It is important to ask the CS because he's the head of public service at this point in time. And as he said, what I've asked is clearly within the aspects of the court case. Could then, do we say that he led the county executive to go against the law or misled the county executive? Because I think he has a technical advice also to the Nandi County Public Service to go ahead and nullify the same process he's trying to say here that we are going against.
CS, would you then defer the same to County? There's a reason I wanted the County Attorney to answer.
Yes.
County Attorney, save your team.
Thank you, Mr. Speaker. First and foremost is to confirm to this House that the matter is before court. Because I understand when the motion was moved, it wasn't very clear whether the matter was before court or not. And I have here with me a statement of claim by Edith Chepchumba, Makirwa, Nelly Chemngetich, and 42 others versus Public Service Board, Nandi County Chief Officer Finance, Nandi County Chief Officer Health and Sanitation, Nandi County Secretary, and Nandi County Assembly as interested party. And it was received, it's actually filed in the Principal Magistrates Court at Kapsabet as employment course number 51 of 2020. And it was filed on 3rd of August 2020. So yes, the matter is before court. Number 2, Mr. Speaker, we haven't received instructions whether from the county executive or the assembly, or indeed we are not aware if the claimants have instructed their counsel to apply to court for an attempt on an out-of-court settlement. So that answers that we haven't yet received instructions to attempt an out-of-court settlement. Number 2, Mr. Chair, is that we are here courtesy of a summon, not really an invitation for consultation. It is a summon, and you have based it majorly on the provisions of Article 195 of the Constitution, and really we know what that means. We know what Article 195 of the Constitution means. So these are serious discussions taking place in this House. It is not a consultation per se. Number 3, Chair, we both know what sub judice means. Sub judice literally means that the matter is before a judge or before a magistrate, and at the very heart of the principle of sub judice is respect for separation of powers, number 1. And number 2 is that you don't want to put any pressure on any judicial officer while determining the matter, so that these proceedings in this county assembly would inadvertently put pressure on the principal magistrate here on the way the matter will be ruled. That's why really, if you look at, in fact, the Contempt of Court Act of 2016, it defines what contempt is. And Section 4B is that there's what we call criminal contempt. And one of the aspects of criminal contempt is that any act which prejudices or interferes or tends to interfere with the due course of any judicial proceeding is actually criminal contempt. And punishment for contempt under Section 28(1) is a sum of 200,000 or 6 months in prison. So really we don't want to appear like we are in contempt of court by proceeding to delve into the very details of what is already being considered in a court of law. So, Chair, you ruled based on Standing Order number 88, specifically 88(2)(c), which talks about civil proceedings shall be deemed to be active when arrangements for hearing such as setting down a case for trial have been made until the proceedings are ended by judgment or discontinuance. Mr. Speaker, respectfully allow me to offer a different opinion, because it doesn't say only setting down. It talks about such as, arrangements for hearing such as. As we speak, today is when the court is giving us a date for hearing, but already the process is on. The process has rolled on, and in my own opinion, if we continue to delve into these issues which are already before court, then we can easily, individually and as a whole, be held in contempt of court with those dire consequences.
County Attorney, one more issue that you are to answer on behalf of your team was the nullification notice on your part. Kindly answer that.
Thank you.
Yes.
Mr. Chair, indeed, counsel for the claimants have already picked that, and it is part of the issues to be determined in court. So it is already being pleaded in court that the board went ahead to issue a nullification notice when the matter is already being adjudicated in court. So, as an honorable member said, two wrongs really, if there was a wrong from the board, two wrongs cannot make a right. And already, the counsel for the claimants have already picked that, and it is one of the issues before court.
Maybe the issue,
Honorable Chair.
the issue here, Honorable Chair,
Yes.
is the fact that you are the county attorney. You are the county attorney.
We'll
This
give
is,
Honorable Fred after Honorable Gideon.
this is an action by, say, a department in the county to nullify a process of recruitment of staff while the matter is in court. You have clearly educated this team, including ourselves here, on the aspects of the law. The question is, why then did the Nandi County Public Service Board went ahead and issue a notice to nullify the said recruitment, knowingly, under also your advice as the county attorney, that that would be sub judice?
Before you can answer, Honorable Fred.
Yangu tu ni,
Honorable Chair.
ni maswali mawili. Nashukuru kwa nafasi, Mheshimiwa Spika. Ya kwanza, nimesikia wakasema waliongea ndio service board wakafuta watu. Ya kwanza, sisi tulikuwa tumeongea na mawaziri. Sisi kama waheshimiwa tulikaa chini na hao watu tukaambia hao watu wafutwi. Sasa ndio walikuwa nashangaa kama mawaziri na support walienda wakaongea wakasema tufute, na ile agreement kati yetu na hawa ilikuwaje? Alafu ya pili, rafiki yangu Atoni, nimeshangaa sana kwa sababu leo umeletwa hapa na wakati waliongea kufuta hao watu, mbona hukuongezwa ndani? Unajua lazima tuelewane kitu kama hiyo. Mbona leo wakati tumewaita bungeni mnalete Atoni hapa ndani, na wakati mkaa chini na mawaziri, mbona mkuuliza Atoni ndio mkafuta hao watu kazi bila kufuata sheria? Sasa hii mwezi kutuambia ati mnafuata sheria na mkufuata, tayari mmefunja sheria. Hiyo gharama ni county government ndio itagharamia. Hata kama unasema mawakili wako kotini, wako pale. Alafu ya pili, ya tatu, ningependa kuuliza akina Atoni. Juzi unajua mimi sijafika mbali, lakini Google. Nikaona Atoni huyu na ule mwingine hawa sio registered kwa wale watu mawakili. Wewe utafanyaje kesi ya kaunti ya Nandi na wewe sio registered? Kwanza unajua tumefuata sana. Wewe kwanza utambuliwe na hao watu mawakili, haruhusiwi kwanza kufanya kesi. Sasa hii umeletwa hapa na sisi tunakulipa mshahara. Tumeona, unajua nimefuata sana. Ile masomo yangu niko naye kidogo, mimi ni mjanja sana. Na hata sasa hii Google muone. Nimeona ni wachache sana ndio wameregister kwa hii kaunti. Wote mawakili wote wa Nandi na wanakula pesa ya kaunti ya Nandi. Mtafanyaje kazi kwa hiyo? Na wewe utambuliwi kwa hiyo. Alafu ya kumalizia.
Honorable members, only one member speaking. Only one member speaking.
Ya kumalizia. Sasa inamaanisha kwamba jinyi executive na MCS hamuelewani? Kwa sababu tumekuwa na David Kamana, tumekaa chini tukaongea juu ya hao watu. Nakumbuka hata mheshimiwa wa Chepkunyu alisema tupunguze hiyo pesa kidogo, alafu tuandike wote. Tukamalizana mpaka tukakuwa na agreement. Baadaye tukaona wamefanya hivyo. Hiyo ndio maana unaona sisi tunashangaa yale kazi mnafanya sio ile tunafanya. Sisi ni MCS na tumechaguliwa na wananchi. Alafu ya mwisho wananchi kuna mawaziri wanasema ati MCS walileta hao watu ati kuharibia sisi jina. Kama nililete mbona ukapatia barua? Inaonekana ukufanya interview. Alafu wale juzi wakasema tena, wakasema ya kwamba ni ile board ndio ilifanya hivyo. Wale walifanya interview ni hawa. Hawa ndio walipatia barua, si ndio amesign. Sasa mnatuambia ati ni ile board ndio walifanya, na mimi nikifutwa leo kabisa bedward. Watakuja kuuliza ule MCA mwenye ameingia ya kwamba mbona hii maji haikuwa. Hawatauliza Fred mwenye ameenda nyumbani. Tunawauliza makosa ni yenyu. Hakuna leo mtatuambia ati watu walifutwa kazi kwa sababu sijui ilikuwa nini, sijui ilikuwa sheria. Kama hii kazi itakuwa true, itaonekana basi hata Attorney General kutoka leo haruhusiwi kufanya kazi kaunti ya Nandi kwa sababu hajui kazi yake. Hata service board hamruhusiwi kufanya board kaunti ya Nandi bila kutumia attorney. Kwani mnatumia nani? Ama kuna kinara ama mheshimiwa gavana alisema vuteni, mnafuta? Gavana alikupropose as CC. Mheshimiwa Fred na the other members wakakupitisha kwa CC. Kama gavana angekusema wewe ni CC na tukatae wewe, haungeenda through. Sasa lazima tuheshimiane kwa sababu hao watu mtuambie mlitumia sheria gani kuwafuta, kwa sababu Attorney hako hapa. Leo unaleta county assembly, jana wakati mlifanya maneno hukulete. Unaona yeye ametoka kwa hiyo lawama tayari. Kwa sababu anasema mlifunja sheria na mawaziri.
Honorable
Honorable
Kipkurui,
Chair.
Honorable Kipkurui, you are the, because I want the county attorney to come
Chair.
back on that issue of nullification. Honorable Kipkurui.
Honorable Chair.
Honorable Ngeti, take a seat, one person at a time. Take
Honor-
a seat, take a seat. Take a
Honorable Chair, I only have one follow-up question to the county attorney, my friend, and earmate in campus, though in different universities, George Tarus. To confirm loudly and very clearly, and I hope the microphone will work, to confirm that the service board erred by proceeding to act to nullify the appointment letters, whereas the matter was before the court. If you can confirm that, Honorable Chair, then we are sitting here knowing that whatever action the service board did is an nullity, and the members, the employees who have their letters are valid until the matter is determined in court.
Honorable Dr. Sanga, quickly.
Chair.
I just wanted to support Honorable Fred. I've been wondering. You know, we had a very nice informal meeting at the governor's place with all the MCAs, and we all agreed. I was just mesmerized by the decision. I don't know if there was someone who had no good faith or no goodwill of what we had agreed, because we really agreed that no one to go home. That was our agreement. We agreed that we can change the terms so that we can reduce the payment so that we can accommodate everyone. We also agreed that the Department of Health will take around 170 staff. The rest to be distributed to other departments. We are really disappointed. We didn't want anyone to go home. I think I wanted to support Honorable.
County Attorney, respond to that one word, because now the ball is in your side. You've made a case on our side, and I'm going to make a determination. But on your side, as the principal legal advisor to the county executive, number one, what was your position, and what next now that the issue, yourself, you are falling into contempt? What is your direction on the same?
Thank you, Chair. I want to respond to 3 questions that have been raised. Number one is that the Public Service Board, remember, is a corporate entity that can sue and be sued in its own name. And in fact, previously they have proceeded to hire lawyers for themselves as a board. So, I don't necessarily advise the board as the acting county attorney. But Section 75, because Mheshimiwa Chepkonya has asked whether the board were indeed in contempt, Section 75 of the County Governments Act allows the Public Service Board to nullify any process if it comes into their light that an irregularity has occurred. The plain reading of Section 75 of the County Governments Act. Number 3, on Mheshimiwa Fred, just allow me to enlighten you a bit that government lawyers are exempted from whatever you were talking about, but be that as it may, we all have taken out our pieces, and whether they are there or on the way coming, we are fully compliant with the requirements of the Law Society Act.
County Attorney, before I can allow Honorable Fred, you've mentioned a very simple question, that it is within the domain of the Public Service Board to act. The same way it is within the domain of the County Assembly, for example, to undertake what you are doing. But what makes the difference is an intervening process, like a court process. So how comes, I don't know why you now refrain, now that you say you don't advise or you act for them, why are you refraining from same application? What applies to us, why not applying to them? Because if it is in court, the same Public Service Board competently having lawyers in court would file that. In fact, as a PO to the court, that even before this matter can be entertained, it is premised on an irregularity. And once it comes to the attention of the court, a PO is given a consideration. And depending on how the magistrate finds the merits of the preliminary objection, if indeed it is identified or found that the premise of the suit is on irregularity, definitely the matter will be thrown out without proceeding to the main suit. Why then preempt that? Why then, as you say and as you advised, a case of giving pressure to the court, directing the court in a particular way. And I hope now we've recorded clearly, as you've said, you're not acting for the Public Service Board. And I want the honorable members to take note of the same. Proceed.
Thank you, Chair. If the board applied Section 75...
Chair, before, kindly, if you may.
Honorable Kipkurui.
My very good friend, George Tarus, my answers are very simple. I am the Ukio Mtata who asks very simple questions. The legal jargon between you and the chair, I will allow you to engage. I've only asked, now that you are aware that the court, the matter was before court, and the board proceeded to nullify the appointment letters, was that not an illegality? It's simple as that. Whether they have powers to hire or fire, we all know. Same case like the chair is saying, we have powers to interrogate and even someone new. But this matter was before court. Was it not an illegality?
Thank you, Mheshimiwa. As I said earlier,
proceed.
If the board applied Section 75 while already the matter is in court, I said earlier that the lawyers for the claimants have already picked that and raised it before the court, and it is one of the issues to be determined by court. If the court sees that they are in contempt, they definitely will be held in contempt of court.
Chair. Now, let me ask this, Honorable Tarus, Mr. George Tarus. As the county attorney, what is your position on that matter? Not speaking now on behalf of the board. As the county attorney, what is your position?
Chairman.
Honorable Fred.
Chairman, nafikiri ningependa, unajua imekuwa, hii maneno nimeshangaa. Ya kwanza, attorney amesema kwamba ukifanya kazi serikali, si lazima ukue active. Wewe utafanyaje kesi? Kama mheshimiwa Kiptoo, yake tumegoogle hapa, yake ni active na anafanya kazi serikali. Hiyo kwanza, unajua unanishangaza, na hata mimi na riski kwa sababu nimekuwa na kesi ya mashamba hapa, wewe ulikuwa unasimamia, na nimeshangaa mbona imekwama, iendelee. Imekwama mpaka wenyewe wakarudi wakatuita hapa na mheshimiwa Chama wakatuambia tumaliza kama county government. Kumbe hiyo ndio ilikuwa makosa. Alafu ya pili, board wanatuambia, attorney ametuambia kwamba pengine board wata hire lawyers. Nani atalipa? Hatukuweka budget. Ile budget tulipanga, tulijua attorney yako na mwenzake wako ndani. Ndio unaona tunashangaa mnatuongezea gharama nyingine county government. Ni kwa ile kitu tumeongea juu yake. Ile kitu tunajua tu ni ile tu kuna interest kwa hiyo kazi. Kuna wale wanataka kuandika watu yao. Kwa sababu wale watu waliandika kaunti ya Nandi ni wale watu maskini. Alafu hao watu mliamuaje, na mnajua kuna wale waliwacha kazi mahali nyingine wakakaa hapa. Na hao watu wamemaliza almost 1 year. Hawajalipo hata shilingi, wamefumilia, wanadaiwa deni ya manyumba. Tayari wako na deni ya manyumba.
Point of order, Honorable Speaker.
I think
honorable members, order,
Chair.
Order, honorable members. Order,
Yes.
honorable Mengech, before I give you opportunity. Order, honorable Mengech. Before you can speak, I think I wanted to guide the House because I'm forced to make a determination. But before then, I'll take comments from your point of order, Honorable Mengech, and then Fred will conclude. Honorable Gideon will give the conclusive remarks. Then I'll have to retreat to make a determination immediately on the PO. Honorable Mengech.
I had an issue, Honorable Chair.
Mengech.
Why are
Honorable
you
Ngetich,
denying
take a
me?
seat. You are out of order, Honorable Ngetich.
No, my only issue, Honorable Speaker, in respect to what Honorable Fred was saying, is delving into the matter before we sort out the preliminary issues. That is my main concern.
Honorable Fred, finish.
I'm sorry, my friend. Unajua ile kitu nilikuwa nataka niulize tu ni kuhusu attorney. Unajua saa hii ukiongea hivyo attorney na tunakutegemea, inaonekana basi kaunti yetu imekufa. Hiyo ndio, na tena unijibu ile maswali nimekuuliza. Service sport walitumia nani? Kwa sababu hawajahaya lawyer mpaka saa hii. Walitumia sheria gani kwa kufuta watu bila kuuliza wale wa sheria wa bunge ya Nandi? Kwa sababu sheria, unaona tunashangaa, unatuambia ati anataka kuhaya lawyers na wewe uko hapa, Mungu karibu watu watatu. Ndio hiyo nikasema mjibu. Na alafu mimi niko na kesi mingi kotini ya mashamba ya kukosana na serikali. Niko na kesi kotini. Ndio nikajua kwamba ule mtu si active, hawezi kufanya kesi kotini. Saa hii unaniambia saa hii sheria inakuruhusu. Na mtu akienda kotini ya kwamba wewe huko unaruhusiwa kwenda kotini kwa sababu you are not active. Sasa itakuwaje? Sitakuwa tumeanguka kwa hiyo kesi.
Honorable Gideon, finally, before I ask for a small time out.
I think, Chair, the issue of this motion, because I brought this up, was from the aspect that it came from the aspect of nullification of the process. If the case could have just continued in court without any form of adverts of nullification, then the chair, I don't think we would have even discussed in this particular county assembly. Because that one was a matter active in court, which should have taken the process. But when they nullified, at least as the representative of the people of Nandi, we should have said and made a determination that the only way you can make a determination is to bring up the matter in the county assembly of Nandi. We cannot continue doing the same thing people do in rallies and funerals. We must also discuss it at the county assembly of Nandi. That is why I'm saying the aspect of bringing this motion as a matter of county importance was to be able to bring to the attention of the honorable members that even as the process was going on in court, this county public service board went ahead to do an advert of nullification. Having said that, I think normally they say in all these processes anyway, you've talked of it was irregular. I want to just make an underrider. You talked of it as irregular.
Point of order, Chair.
Let him finish. Because
No, point of order, because, Chair,
Honorable
we have not determined
But
whether we should proceed, because
I am
what
saying, Honorable
Gideon-
Mengech,
Yes.
Honorable Mengech, I've said I want to make a determination. I was just giving close remarks of chair before I proceed to make a determination.
Chair, what
Honorable
Honorable-
Mengech,
what Honorable Gideon is raising is delving into.
Honorable Mengech, before you speak, let me give you the opportunity. Before you speak, Honorable Mengech, you are correct, your point of order is correct, and I've answered that I'm proceeding. However, I had no problem entertaining what he was saying just for my consideration, and we will not proceed unless I make that determination. So you are well covered by ensuring that we will not proceed unless I'm able to. This was just basically a comment which aids or helps in what I am considering. Kindly. Finish, Honorable Gideon.
Just so that I'm not even still proceeding because I think that is a matter you are going to conclude, Honorable Speaker, but I just wanted to say that we need to make sure that as we try to do things within the law, let us broadly think about the entire processes that we have.
Honorable members, judging by the issue at hand, I will ask all honorable members together with the executive to remain seated. I will take exactly 5 minutes, come back, give a considered judgment, and proceed and give a way forward. So no one to move, take a seat, and I come back with the same determination.
Sioni kama wataproceed. Kala magari mtotos proceed. Magari kaya mutinye lawyer Mr. Ajay. Majab ko discuss on the issue of